Hello, and thanks for joining me for this conversation about supported decision-making in New Jersey. I'm Michael Brower, a managing attorney at Disability Rights New Jersey. I'm recording this session on May 14th, 2021. I hope you find it both informative and helpful. Please note that I will speak generally about legal concepts and laws, but this presentation contains no legal advice. If you want legal advice specific to your situation, contact information will appear at the end of this presentation so that you can request services from Disability Rights New Jersey. You can also consult your own attorney. Let's get started. First, you probably know a little bit about Disability Rights New Jersey and what we do. Just in case you have not heard of us before, let me give you an introduction. Disability Rights New Jersey is a private, nonprofit agency funded with private donations and grants from the federal and state government. We advocate for the rights of individuals with disabilities statewide. On the screen is a picture of 5 of my current and former colleagues handing out brochures at an outreach event. As New Jersey's designated protection and advocacy agency since 1994, it is our mission to preserve the human, civil, and legal rights of persons with disabilities, empowering equality through persistence, awareness, and expertise. Disability Rights New Jersey provides legal assistance to individuals with disabilities in issue areas such as abuse or neglect, discrimination, voting rights, access to services and supports, and employment. In addition to individual representation, Disability Rights has the unique authority under federal law to monitor for and investigate abuse and neglect in any facility that serves people with disabilities. My practice focuses on advancing the civil rights of people with disabilities who live in the community, such as their own home, a group home, or a family home. Other teams at Disability Rights New Jersey focus on other populations, such as people who live in institutions, people seeking employment, the right to vote, recipients of Social Security, or children in the criminal justice system. Today, we're going to talk about supported decision-making. By necessity, we will have to compare and contrast with guardianship. We will compare the two concepts and talk about how they work in the grander decision-making scheme we all use every day. We'll also talk about powers of attorney, which can serve as less restrictive alternatives to guardianship in some situations. By the end of this presentation, you should be able to define supported decision-making, differentiate it from guardianship, and identify at least 3 types of powers of attorney that could be used instead of or to prevent the need for guardianship. Regardless of whether you have a disability or not, have you ever used supported decision-making? Let's do a little thought exercise to get you warmed up to this idea. People make decisions all the time, and regardless of whether or not you consider yourself to have a disability, it's probably rare that you make a decision completely independently. Those decisions range from the smallest, almost insignificant, like what color tie should I wear today, to the very serious, what kind of medical care do I want if I were to become gravely ill? Let's pick something in the middle, and we'll work our way through the process to help lay groundwork for our discussion. Because we're all probably sitting in New Jersey, most of us have either driven a car or ridden in one. Hopefully, that gives us a common experience that we can draw from. On the screen are 2 pictures. One is a man staring with despair into his engine bay on the side of the road. The other is a happy mechanic, giving a thumbs up. Here's the scenario for our thought experiment. Your car stalls on the highway while you're on a road trip. You're far from home, and you don't know what happened. All of a sudden, though, your car lost power, and you are slowing down. You don't have a lot of time before this situation gets dangerous. Now, what are you going to do? Maybe you decide to pull over, get into the shoulder, put on the flashers, and call a tow truck. How would you have known to do those things? Did somebody teach you in a classroom? Do you have some experience as a driver or maybe as a passenger in a broken down vehicle? If you had neither training nor experience, would you naturally know what to do when your car loses power? Let's say you call the tow truck, and it tows you to the mechanic's shop in the local area. How do you decide what to do next? Do you speak with the mechanic, get an estimate for repair, or start thinking about the car is worth fixing? Could you make a good decision about any of those things as soon as you arrived out of the tow truck? You probably needed more information than you currently have. Maybe you let the mechanic take a look. They come back to you with a diagnosis and an estimate for the cost of repair. What if the mechanic starts talking to you about spark coils, carburetors, fuel injectors, or clutch cylinders, but you've got no idea what any of those things are? Maybe you just ran out of gas and all you really need is some more fuel. Maybe you blew a head gasket and you just don't know what to do next. After hearing from the mechanic on what's wrong with the car and how much they think it'll cost to fix, maybe you call your sibling who fixes cars for a hobby to help you understand the situation. Maybe you'll call your normal trusted mechanic who you know will give you an honest answer about what those repairs sound like. Maybe you need to know how far you are from your destination, or how serious it will be if you arrive there late or at all. Maybe you just need to know, is there a rental car agency nearby? Before you get all that information, again I ask, were you competent to decide what to do? And in any of those situations, who is ultimately responsible to decide? Even if the mechanic makes a recommendation, you and your brother agree, do any of those other people decide? No, of course not. You do. Or maybe all of those decisions were just too overwhelming and you don't make any of them. We're right back where your car first stalled. You coast slowly into a ditch, you get out, and you walk away. You decide not to decide. That's still an exercise in decision making. There really is no escape. Here's a picture of what happened to that car. It's a rusting vehicle parked in some tall weeds. No matter how the situation with your car came out, you probably just used some form of supported decision making to respond to an unexpected problem. You got information, explanations, and even maybe some help communicating from the mechanic, your gearhead sibling, or your coworker who calmed you down and promised to cover the big business meeting that you're on your way to get to. If you had never had a car break down on you, or if you'd never dealt with a mechanic one-on-one, it might have been very stressful. Even if you had done all of that before, you still might have needed some or all of those same supports to make good decisions. Those same kinds of decisions come up all the time, and people pretty typically will seek out support. Folks might talk to their doctor before they undertake a big medical procedure or get a second opinion. They might talk to friends or even strangers on Facebook before they rent an apartment in a new city. People talk with their family before they make major career moves. Or they call on people that they just know that have level heads for advice when they find themselves in a stressful situation. And sometimes, even with help, people make mistakes, or they decide on a course of action without fully understanding all of the risks. Renting an apartment in a nice part of town, but then finding out that it's right over top of a noisy train line. Or getting a tattoo of your ex-girlfriend's name. Think about all the wealthy people who are surrounded by experienced financial advisors that still ended up investing with Bernie Madoff because they didn't truly understand what they were getting into. Even with all the support in the world, people make mistakes, but we're allowed to make mistakes and hopefully learn from them. In all these situations, from the stalled engine to Bernie Madoff, we're assuming that the person in charge is you. You told the mechanic to fix the engine. You considered the advice and the input that you received on any one of those decisions. You listened to some, you rejected some others, but finally it was you who decided what to do. That's all supported decision making. Now, not every decision is supported. Some people might seek no input on small or even large decisions and decide only based on what's already inside their brain at that moment. The tie example is a good one. You look in the closet, you grab a color of a tie without consulting anybody else, and you know what, it probably doesn't really matter. Maybe you'll look a little silly that day if you got the wrong color. Typically though, the more consequential or the more consequences that come with a decision, the more we tend to seek out some level of support. So up on the screen is an arrow. It points from the left to the right with 4 colored dots on it. The first 3 dots from the left to the right are gray, and they're labeled in order: independent, supported, and surrogate. The last and 4th dot is blue, all the way on the right-hand side of the screen. It's labeled substitute. We're going to refer back to this arrow later, so keep a picture of it in your mind. If you look at deciding from the perspective of who is the decider, you'll see that these things start to line up into the same spectrum that lines up with our arrow. The more input you have from other people, or the more that input matters, the further from independent decision making we go. We've talked about independent decision making and supported decision making with a few examples already. In both of those, remember, you are the ultimate decider, either drawing on things that are already in your brain or support in real time to help you understand your decision. The next dot further down the arrow is surrogate. Surrogate decision making is when someone else decides for you, but they make the decision based on your values and your documented or expressed wishes. Sometimes you might be able to overrule that decision maker, but not always. This is called surrogate decision making because somebody's standing in for you. They're making the decision as if they were standing in your shoes. We're going to talk about surrogate decision making a little bit more when we get to powers of attorney near the end of the seminar. If we move to the last dot on the arrow all the way to the right, we have a dot that's blue labeled substitute. A substitute decision maker makes decisions for you based on what they think is good for you. They might apply objective standards like the best interest, what's best for you, or they might even consider your wishes, but they don't have to. In all situations, when you have a substitute decision maker, they are the ones deciding and not you. In that broken down car scenario that we started off with, this is like if you called your brother to let him know about the breakdown and he took over from there. He talked to the mechanic, decided how much to spend on getting the car repaired, whether to scrap it, whether to get you a rental. None of that was your decision. It was all your brother's. In a substitute decision-making scheme, you're the passenger in a decision-making process. A full guardianship is the most common example of a substitute decision-making scheme. This is why we consider full guardianships to be the most restrictive decision-making mechanism, because you no longer have control over decisions in your own life. Somebody else does. Speaking of guardianship as a restrictive mechanism, if you zoom out to a global perspective, you'll see that other parts of the world have differing views on decision-making for people with a cognitive disability. Up on the screen is a map of the world, and countries are colored in either as yellow, red, or different shades of blue. The United Nations sponsored a convention on the rights of persons with disabilities. The convention says that state parties shall recognize that persons with disabilities enjoy legal capacity on the equal basis of others in all aspects of life, and this includes the right to exercise your legal capacity. For our conversation today, we can simplify the UN Convention by saying that it outlaws removing someone's legal capacity to decide something for themselves only because they have a disability. It requires countries to modify their legal systems to recognize that at least some form of supported decision-making can work for people with disabilities, even if those disabilities affect the way they think. Countries in yellow on this map have signed the convention, but have not adopted it into law. Red or blue shaded countries have adopted the convention as law. You'll see that the US is yellow. That's because we've signed the treaty, but our Senate has never ratified it. Therefore, the UN Convention does not have the force of law in the United States. Other signatory nations that did not adopt or ratify the convention include Ireland, Libya, Chad, Belarus, Uzbekistan, Kyrgyzstan, and Bhutan. For us, this means that decision-making is governed state by state because there is no uniform law across the United States. Now that we've laid some groundwork about the fundamentals of decision-making and gotten our international and national perspectives, we can turn to the core of our session's focus, supported decision-making in New Jersey. Some states have a statutory scheme, that is, laws in the books, to define how supported decision-making works in relation to guardianship. New Jersey does not have a supported decision-making law on our books. The other states will do things for supported decision-making laws that usually will address problems that people with disabilities have interacting with third parties. So here's a couple examples. A state law for supported decision might say something like giving a doctor informed consent to perform a medical procedure, or handling money at the bank, or even contracting with somebody else to exchange goods or money. Those state laws would typically tell those other people that it's okay to accept a person with disabilities decision so long as that person has taken certain steps, like entering into a written supported decision-making agreement. We don't have that kind of law in New Jersey. Here, supported decision-making is whatever we make of it. That means some doctors might recognize that a person with disabilities has consulted with supporters or is able to give informed consent. where other doctors may not agree to perform a procedure if they don't think that their patient understands the risks and benefits involved, even if the patient has consulted with their supporters. We're going to talk in a minute about how our guardianship statutes and case law from the courts still require some level of supported decision-making for people who are subject to a guardianship, but let's hold that off for later. For people with disabilities who are not subject to a guardianship, the Americans with Disabilities Act and the New Jersey Law Against Discrimination make it illegal to discriminate against someone because of their disability. Discrimination includes access to medical care, or denying access to medical care, or denying access to businesses open to the public like restaurants, denying access to government services or offices, or government programs. Because we have the Americans with Disabilities Act and the Law Against Discrimination, or even some of the non-discrimination parts of the Affordable Care Act, you might have heard of it as Obamacare, because of those provisions, our example of the doctor, if they denied treating a person with cognitive disabilities, they might incur liability under those anti-discrimination statutes. And, we can think about this with a pretty easy to understand, something that maybe we've heard about all a little bit more commonly. If somebody who is deaf walks into a doctor's office, we wouldn't bat an eye to learn that a doctor's office legally is required to provide a sign language interpreter or closed captioning for a deaf patient. Wouldn't it be similar? Would those accommodations be very different if a doctor had a patient with intellectual disabilities, that is, making sure to speak in terms the person understands, and making sure that when they communicate with that individual, all the communications are both effective and complete and accommodate the disability? And even though we don't have a national law or even a New Jersey level supported decision-making law, it doesn't mean that supported decision-making doesn't exist here. And like we talked about, decision-making isn't all that different for people with cognitive disabilities, whether that disability is developmental or psychiatric, or if it comes from a brain injury. The difference might be how far into routine decisions you need support, or how heavily you rely on those supporters to make your decision. Supported decision-making in New Jersey could be anything you want. It might be informal, where supporters only get involved when you need them, or it might be more formal, where you have a written document on who's involved, a regular meeting schedule, a designation on who helps you with what decisions. On the screen, I have a picture of former President Barack Obama. He's seated at a conference table surrounded by advisors in the White House. This is an example of a formal supported decision-making arrangement. Formal support can come from anywhere. Family and friends can be part of a formal arrangement, so could professional staff. While the president might select diplomats, speechwriters, and treasury secretaries, you might designate caregivers, doctors, accountants, clergy, lawyers, or social workers to help you make your decisions. How formal it is up to you. There's some good sample supported decision-making arrangements at supporteddecisionmaking.org. I'll include a link with this presentation. These forms are meant to help you document or clarify the role of any supporters in your arrangement so that everybody knows what their job is, and if you needed to, you could reference it later. On that note, on whose job it is, beware somebody who claims to be a supported decision maker for you. Think back to our arrow in the continuum of decision making. Supported decision making revolves around maintaining self-determination so that nobody but you has the authority to decide what happens in your life. Everyone else either supports you in making a decision, or they support you in communicating your decision. If somebody in your supported decision-making arrangement starts to decide for you, then we're sliding towards either surrogate or substitute decision-making, and we're sliding out of supported decision-making. Now that we've completed a discussion about what decision-making is generally and how we define supported decision-making, let's introduce guardianship into the mix. To really understand guardianship, you need to know a little about its origins. Like many legal schemes, guardianship has its roots in English common law. In medieval England, the king or the queen was the figurative parent of all the subjects. The people of the land were children, and like any parent, the king or the queen had a duty to protect them, or especially to protect those who couldn't protect themselves. The power in practice was generally applied to actual children who either were orphaned or had adults who wouldn't care for them, or adults who had some kind of a cognitive disability. This general concept of law transferred across the ocean into the American colonies and evolved significantly after the years of our independence. In the modern United States, we see this power come about in the form of various child protective service agencies for the state, and for adults, our guardianship system. In this model, remember that the state, the substitute for the old king or the queen, is the holder of the power. So when we talk about appointing a guardian, it's just that. The court, on behalf of the state, appoints a guardian to carry out decisions for the incapacitated person. Ultimately, even though there's a guardian, the court is retaining the authority to decide on any given matter, or to appoint a new guardian to carry out the administration of the parental power if the court has some reason to do that. This arrangement is all the way to the right on our decision-making arrow. That means the court or the guardian are substituting their judgment to make decisions for you. We have specific guardianship statutes for adults in New Jersey, and there's a few of the most important excerpts I cited here up on the screen. You want to focus first on the standard for incapacity, because that's the gateway. Only incapacitated people need guardians under the law. Our law says that an individual who is impaired by reason of mental illness or intellectual disability, to the extent that that individual lacks sufficient capacity to govern himself and manage his affairs, needs a guardian. Note how that's a little bit circular. Somebody's incapacitated only if they don't have capacity to govern themselves. Well, that doesn't really tell us much, does it? But that's all the guidance we're going to get from the statutes. In practice, this means it's a pretty subjective standard. And because the rules of evidence and the rules of court require two doctors to certify to incapacity, it comes down to those two doctors' opinions, and it probably makes a difference which two doctors you pick. The guardianship statutes currently allow, but do not require, judges to consider whether a limited guardianship would work before they apply a plenary or full guardianship. Limiting guardianship is exactly what it sounds like. The guardian does not have full decision-making power in all circumstances. The guardian's power is limited. If the court decides to appoint a limited guardian, it must make specific findings on each of the domains of decision-making. So the different domains, I think of them as the areas of decision-making. In the law, that's defined as residential decision-making, educational, medical, legal, vocational, and financial. The court could, of course, divvy up those into more specific areas of decision-making to give either between the guardian or you. Remember when I said just a second ago that the standard for incapacity was very subjective, and it really only required the certification of two doctors who agreed that you need a guardian? Since 2016, the standard actually got even lower for adults who qualify to receive services from the Division of Developmental Disabilities, or DDD. If you're approved to receive DDD services, there only needs to be one physician or psychologist who certifies that you have no capacity, accompanied either by a certification from DDD itself, a licensed care professional, or even just a copy of your IEP, as long as it was made within the last 2 years. Up on the screen, I have a picture of a wide paintbrush, because these rules make it easier to get a guardianship over somebody in the DDD system by painting them with a broad brush. Even people who the court finds to need a general guardian for all decisions still retain some important rights. First, guardians are required to give due regard to the preferences of the ward. All right, time out. Let's take a little side trip on the word ward. Batman had a ward. His name was Robin. In my eyes, that's really the only ward. And I know a lot of people find this to be an offensive term. I'm using it here only because it's accurate with what's written in the statute, and I want to give you accurate information, not trying to offend anybody. All right. Like I was saying, the guardian has to give due regard to the ward's preferences and must also take reasonable inquiries to find out what those preferences are. The guardian must encourage the ward to participate in the decision-making process to the maximum extent of the ward's ability, and with the goal of developing or regaining higher capacity in areas where the ward needs a guardian. Sounds a little bit like supported decision-making, doesn't it? And it's good to note that the statutes in this area don't say this is the guardian can, or the guardian might, or the guardian should. The guardian must do these things. The guardian must involve the ward in the decision-making process and give due regard to their preferences. Of course, giving due regard, or even involving the person in the decision-making process, might mean listening to you and then overruling you if they disagree. What might you do if you have a guardian, but either the guardian or some third person is not respecting your wishes? There are some Supreme Court cases in New Jersey that might tell us here. They discuss the rights that are retained by people who are in a guardianship, even if the court has already found that that person needs a full guardian, meaning it's not limited, it's the most restrictive type. First, we want to talk about a case called In Re Grady, and it's good just to have heard this before and know the case is called In Re Grady. It's a case about some parents who are appointed to be the general guardian, and really the subject of the case is their adult daughter. She has Down syndrome. And there's no contest. She doesn't believe that she has the capacity to govern herself or manage her own affairs. But she knows that she's an adult and she wants to be sexually active. She's not very good at remembering to use birth control. And the guardians have decided, along with her, they've given her preferences due regard, that a sterilization procedure would help her be sexually active without the worry of becoming a parent. The hospital where they take her won't perform the procedure without a court order. Essentially, the hospital says the guardians can't even consent to sterilization on behalf of the ward, even if the ward herself wants it. The guardians go to the trial court trying to get a court order. They get denied, and the matter ends up before the Supreme Court of New Jersey. The Supreme Court says that we should be reluctant to substitute our consent for any person who may be capable of making a decision for themselves. Here we have the court trying to balance out a right of an incapacitated person to choose or to make their own decisions for a medical procedure. On the other hand, they're trying to balance informed consent, making sure that people understand the medical procedures that are being conducted before they happen. So courts in this situation have to make specific findings that an individual lacks capacity to consent or withhold consent only after the court decides that somebody doesn't have the ability to consent to a medical procedure should the court or the guardian step in and apply a best interest standard that might ignore the person's expressed wishes. There's another important Supreme Court case that's worth mentioning called the Matter of M.R. It's worth going to Google and find it and read the text of this case. I'll try to attach a copy to the presentation for your convenience. This is a case, again, from the New Jersey Supreme Court that discusses what the court should do if someone challenges your right to make a decision, again, even if you already have a full guardian. The court wrote, "We are reminded also that the mere fact that a person is generally incompetent does not mean that person is incompetent for all purposes. A person who is generally incompetent can still make choices about specific matters," end quote. And the court goes on to say, quote, "We recognize the argument that as a decision increases in importance, so should the right of the affected person to make that decision. Our goal is to permit developmentally disabled people to make as many decisions as possible while protecting them from the harmful effects of bad decisions that they do not fully understand." So what the court is saying here, that we are going to start with a default of listening to an individual's preferences. If you're the person in a guardianship, listening to your preferences, and only will we overrule those preferences if the person challenging your right to decide comes with specific evidence that you don't understand that decision. Again, this is pretty big because we're talking about people who are already in a general guardianship are getting the right to decide things, and only when somebody else can prove with some convincing evidence that you don't understand will you get overruled. That's a big decision. Like I said, it's important to go read MR if you have the time. So unless you're completely unable to communicate your preferences, say you're in a coma, for example, the guardian has a duty to encourage your participation in the decision-making process and to respect your expressed opinions as much as possible. When your guardian disagrees with you and you feel strongly, you could ask the court to hold a hearing where the guardian has to prove why your opinion should not be honored. There are court rules that specifically outline the rights of people who are in guardianships to always ask the court to review decisions, review the guardianship as a whole, or even request an attorney to help them review the guardianship. If you look up on my screen, I've got two big blue ovals, and this really is the result of our comparison between guardianship and supported decision making. You can see they're not mutually exclusive. Where they overlap, which is almost all of guardianship, people with guardians should still be involved in their own decisions. That little slice of guardianship that falls outside of the supported decision-making oval, that's those folks I was saying before that cannot communicate their preferences, whether that's verbally, visually, or even with the aid of some assistive technology such as an eye tracker or a communication board. Only then does guardianship really diverge from supported decision-making. All right, now we've defined supported decision-making. We've explored where it differs and where it overlaps with guardianship. Next, we're going to talk about a few alternatives to guardianship that help preserve self-determination for you if you have a disability that affects thinking or remembering. Many people, for many reasons, delegate decision-making authority voluntarily to another person through a document that's called a power of attorney. If you're a person with a disability, you might use a power of attorney as part of your supported decision-making arrangement to give, again, voluntarily, a supporter the power to handle some part of your life. This authority is concurrent, so that means that you could revoke it at any time. You keep the power that you give. You don't give it away permanently. That means that you could appoint a new person to act as your power of attorney. You might be able to override a particular decision if that power of attorney is not carrying out their job in line with your expectations. And if you think about powers of attorney, remember that arrow of decision making? This is surrogate decision making. So we're close to guardianship, but we're not there. And the reason we're not there is because these are voluntary arrangements. So this is surrogate decision making, where the person you appoint, your agent, stands in and makes decisions for you the way that you would make decisions for yourself. They stand in your shoes. If you already have a guardian, you can't grant a power of attorney in the area of decision making if the court found that you lacked capacity in that area, because the court has already appointed somebody to make those decisions for you. It's not voluntary in that court situation. The power of attorney should be directing their decisions based on any documented decision-making criteria from you, either when you first established your relationship in the document that you used to form the power of attorney, or by the power of attorney talking with you and getting information about how you would want the decision to be made. For example, in a healthcare situation, you might write down what kind of health treatment you want, what you don't want, and under which circumstances you would want medical treatment to stop. If you had a financial power of attorney, you would direct your agent how you'd want them to handle, invest, or spend your money. The designated agent doesn't use their judgment. They don't think what's good for you. They apply your judgment. What do you want for yourself? Even if that judgment wasn't explicit, they could use other evidence about what you might want to inform their decisions if they can't get in touch with you. With a general power of attorney, you're granting specific powers, and they can be almost anything that you want, for a specific purpose, to a specific person, for a definite period of time. If you had a general power of attorney in New Jersey and then you became disabled to the point where you lost capacity, the power of attorney would expire, and the person you appointed would no longer have any power to make a decision for you. You control which powers you give to that power of attorney, and if at any stage you disagree with what they were doing, you could revoke the power or you could replace them. A durable power of attorney is the same as a general power of attorney, except for one important thing. It could continue even if you became more disabled and lost your ability to decide, or in a legal term, lost your capacity. Many durable power of attorneys are also written with a special feature that they don't even take effect. That is, the person you appoint doesn't have any permission to handle your decisions unless you lose your capacity, meaning that you get to decide for yourself, and if for some reason you lose your capacity, automatically that power of attorney will spring into effect and you have an agent with all the instructions they need to decide things for you the way you would have decided them for yourself. Now, you might lose capacity suddenly in a thing like a car accident or you become unconscious. You have anesthesia from a surgery and the surgery goes poorly or just takes longer than expected. Or maybe you have a temporary or permanent drop in your ability to communicate or to think, or to become, maybe you became impaired from drugs or illness or some other injury. In any of those situations, a durable power of attorney would continue per the specific instructions in anyone's power of attorney. A medical power of attorney, the last type here, is also known in New Jersey as a healthcare proxy. This is a special kind of power of attorney that only deals with medical decisions. Because medical decisions are so individualized and they deal with your body, medical power of attorney only take effect if you're unable yourself to communicate your decisions, or if your doctors certify that you don't understand or cannot manage your medical condition and treatment any longer. Only then will medical powers of attorney take effect. Again, in any of these situations, the power of attorney is acting the way that you would make the decisions for yourself, not what they think is good for you. Speaking about medical powers of attorney or healthcare proxies, this is one of the most common things that people would like to complete. The good news is the New Jersey Department of Health provides free fillable forms online that you can use if you want to set one up. Even if you don't have a disability, or if you're not worried at all about your health right now, it's a good idea to set up a healthcare proxy, because you never know when something can happen. If you were to suddenly lose your ability to decide or to communicate medical decisions, if you have a medical proxy, at least someone will be able to manage your medical affairs and carry them out in a way that you would have wanted. Otherwise, you might end up living on life support longer than you would want, or you might forgo an experimental treatment that you would have wanted to try before somebody pulled the plug. That concludes our presentation on supported decision-making and guardianship in New Jersey. On the screen now are the contact information, our Facebook, our Twitter, our website, our phone number, our fax, our TTY line. If you have a specific case question that we didn't cover here, of course I would encourage you to contact our intake office and request services from Disability Rights New Jersey. I want to thank you for taking the time to view this presentation, and I wish you good health. Goodbye.